of work on their upgrades and updates. I use this all in my training sessions, there's videos and audio stuff. There's a lot of updated stuff, including your virtual screens. I see, Matt, you've got yours with your company logo on it, which is great.
Well, the updates you just showed us were the most useful things. I'm glad they put all that effort into that.
Yeah, definitely. What kind of law do you practice?
Intellectual property law.
Well, can you imagine getting on with a brand new client with this?
I like that, Rob.
Yeah, I think it's version 5.1. You can go into Zoom and just check your settings and see if you're due for an upgrade.
See, I learned something already today.
There you go.
It's only 8:02 and I've already learned something.
Now, soon it's going to be, since we're talking about intellectual property today, it's going to be licensed images. So, where you want to pick the tie that you're going to virtually put on instead of, the actual one, it'll be Hermes, you'll have to pay a fee.
Yeah.
Now you're thinking.
We had a meeting yesterday.
Morning, guys.
Talking about how the apps and technology are just accelerating, where every day there's a new type of video technology, sound technology that's just making this experience more and more enhanced. This is where people are flocking to, less in person, more this type of meeting. So Zoom is, the other platforms also, they put a lot of work into this, trying to make it easier, more user-friendly, and people have gotten better at it.
Neil, are we giving it to a particular time?
Yeah, so what we're going to do is, what I'd like to do now is just have people introduce themselves so that you know who the audience is and everybody can introduce you. And then we're going to, we have a lot of new members that we're going to talk about and welcome them. One of them just popped on, Jeffrey Rosen and Rob Fishman. And at least everybody get to know everybody a little bit, and then we'll start the presentation. So starting around the room, Larry, if you just want to introduce yourself.
Morning, everybody. Larry Bloom with Bloom Schoen CPAs. We're a full-service CPA firm in Jericho, New York.
Eric.
Good morning, Eric Freed, CPA, Janover LLC, accounting firm with offices in Garden City and Madison Avenue, New York City.
And Plainview too, right?
And Plainview, where I'm sitting now.
Yes. Rob, welcome. Rob's a new member, and he's also given presentation in the past. Tremendous friend with Sandler Training. So, Rob,
good morning. Thank you. Good morning, everybody. Rob Fishman, president and owner of Sandler Training. We focus on client development, business development, revenue, strategy, systems and processes, as well as the skills that people need to get more business.
Terrific. And Scott?
He's muted.
Scott Lewis is not muted anymore. Good morning, everyone. Scott deals in the insurance world, as well as Medicare and employee benefits. And he's back in quarantine for another week. After driving down to Florida to see the
Yes.
long drive. Whew.
Yes. Well, it's good to see you back. Daniel?
Back.
Morning, everyone. Donnie Schulman. I'm a client strategist for BNY Mellon Wealth Management. We work with high net worth, ultra high net worth families, business owners, and right now nonprofit institutions. We focus on all aspects of wealth management, including investments, how to borrow, managing taxes, and protecting assets.
Tim? Thank you.
Hey, good morning. Tim Kennedy with U.S. Mortgage Corporation. I'm a certified reverse mortgage professional, educating professionals like yourself using a reverse mortgage as a tax-efficient retirement income tool. Thank you, Neil.
Thank you. And Phil?
Hi, good morning, everyone. Phil Kenyuk, partner over at Nussbaum, Berg, Klein, Wolpal, and my niche is business valuation and forensic accounting damages. Welcome, Rob. Good to see a new member, especially with your background.
Thank you.
Jeffrey Rosen, another new member. If you want to introduce yourself. I know we can't see you, but
Welcome.
you're muted. If you want to unmute. Okay, we can get back to you. Neelam, Jane, I have not met you before. Good morning. So for those of you who don't know me, Neil Himmelstein, I co-chair the LIFPN, Long Island Financial Planning Network, which many of you have participated in throughout the year. We do appreciate it. I'm an independent insurance wholesaler, life insurance, annuities, disability, long-term care. I specialize in a lot of high net worth planning, premium financing, and sophisticated planning is my forte. And I'm very, very happy, first off, to see that our membership is growing. And all you new members, if you would please send us your bios, and existing members, we would like to post it on our new website, lifpn.org. And I'd also like to introduce you today to someone I've known his whole life, Matthew Asbel. Yes, we are related, so that's why I know him his whole life. And Matthew is, as far as background goes, I believe at one time was a professional musician, studied medicine, and happens to be one of those things called a lawyer, that has a very specific niche in intellectual property. And with that, Matt, take it away.
Thanks very much, Neil, and good morning again, everybody. So I am going to share a screen with you. I can't share a screen, apparently.
Yes, you can. Hold on a second. We have the technology.
Yes, I can. Hold on. Okay. It said that the host disabled sharing. It's always a problem with those.
I'll get
You got to watch those hosts. Try to get those hosts better. So while we're waiting, my grandmother was Bertha Himmelstein, just so you know, since you were looking for the name connection. So while I'm waiting for Neil.
There you go.
All right, let's see here. Screen 2. You should now see slides. There we go. All right. So you don't see me anymore, and I don't see the chat anymore. So if you do,
I only see you.
You do see me?
I only see
We don't see the screen share.
That's weird. That's all I see.
What did I do here?
Hold on one second. Let me see what I can do here. Okay, hold on. I got it. All right, let's see if this does it.
There we go.
Although
Perfect.
this is
Much better.
actually, I'm going to do one. I'm going to do one more change. Sorry, bear with me a second. What do I got to do here? Let's see. Stop sharing the screen. Oops, that's video. Stop sharing the screen. I'm going to share the other screen and switch them over because Zoom is forcing me not to see the slides in the presentation mode. So here we'll go. We'll try this one more time. Share screen 1 this time. Now you'll see Zoom. So it should say nothing interesting to you. And now, there. Do you see the slides now?
Yes.
Yes.
Yeah,
All
we
right.
see your version of the presentation mode. If I can make a suggestion, Matt, is I would not put it into slideshow mode.
And just do it in the regular slide version.
Do the regular mode, and you can actually just reduce the size of the slides on the left side. Just slide that over so they're minimum. Right. Just make it easy for you.
Thank you.
Sure.
Good to have a trainer on the call.
Yeah, I've made this mistake numerous times.
This is all coming from that snide remark I made about how everybody on the calls is a Zoom novice. Okay, so let's try it one more time. We will share screen. I'm going to go with screen 1 this time. All right, so and you want me to minimize the outline view is what you're suggesting.
Yeah, just make that smaller. There you go.
There we go. All right.
And if you really want to get technical, see where it says click to add notes on the bottom of your slide?
Yeah, I can move that down too.
Drag that all the way to the bottom.
Great. All right. Well, thank you very much. All right. So sorry for the delays. So, so we're going to talk about intellectual property as an asset because my area of practice is intellectual property. I've had my entire legal career devoted to private practice at firms, doing intellectual property law domestically and internationally. As Neil told you, I have a background in music and in medicine. But I actually also have, I've also been a software trainer, believe it or not, even in Microsoft Office products. But in the pressure of the moment, can't always necessarily go to that part of my brain. Anyway, I've been a songwriter, musician. I'm a foodie, and I'm into international culture. So I've got a lot of seemingly very diverse interests and backgrounds, but that is actually what has tied everything together for me and why I practice intellectual property law, because basically all of those different areas are things that have driven me to that, and intellectual property law plays a role there in all those ways. I'm also, apart from being a practicing lawyer, I'm a law professor. I teach a class starting again tomorrow night, beginning of the semester, all remote, lucky us. I frequently am a speaker and author and mentor of junior attorneys interested in this field. I just moved. This is actually a new firm for me. I just moved here May 1st. I came from a firm that's very well known historically called Lattice & Parry. Was an international intellectual property boutique law firm that at one point represented something like 335 of the Fortune 500 companies. My whole career has been there, and I just moved over to Offit Kerman, which is a general practice firm. So now within my firm at Offit Kerman, I am, I'm going to shut off my Outlook, sorry. I am one of fewer people in an IP department, and you know, and there are people I'm working with who have practice areas that are related and relevant to what I do, and get to work with them, which is terrific. The firm has a non-exclusive focus on small and mid-sized businesses and high net worth individuals. I have some larger clients as well that are multinational and startups that are very, very far along. And the firm is actually one of the country's fastest growing firms. And what's interesting about them, I guess, just to tell you very quickly, is that it's extremely transparent and metrics driven firm, and everything's taken with a very business friendly, practical approach, which I've been really appreciative of. So that's enough about me. Let's talk about our topic for the day. So I put up here, in my view, why accountants and financial planners should want to talk about intellectual property, because perhaps it's not something that you know, you would think you would need to talk about. For one, of course, intellectual property is often the most valuable asset of a company. So it is, it regularly comes up. But what a lot of people don't realize is different kinds of intellectual property have different characteristics, and characteristics that make them different from other types of assets, and they're frequently just lumped in together with other assets, you know, and sort of not really given the right amount of attention. So so hopefully I'll help you to pay the right amount of attention and not have it be too late. There's also often a failure to recognize intellectual property, that there exists intellectual property in something that someone is doing or has, and then utilizing that as a source of revenue. So hopefully I can help you to recognize that for your clients when there might be some intellectual property issue. And then you can call me and make me very happy, or call others. What you might not realize is that it also can be a source of liability. It can be a source of continued costs and risks. And there are things to understand about that as well. when the client has intellectual property or has interest in intellectual property. And for reasons I'm going to explain later on, sometimes the intellectual property is very ill-defined as a function of the way the law creates it. And people get commonly confused between different types of intellectual property and whether there are any rights available at all. And then how do you use that in terms of your planning if you're going to want to list it on a balance sheet or an agreement or something of that nature. So this was my interpretation of what I think you would want to know. I, of course, welcome your questions and comments, as to other aspects if these do not hit on things that would interest you. But of course, my slides do follow along this line. So, now that we've talked about why you should be interested in it, the question is really, what is it? And if you want to just sort of think about it very broadly, it's basically the fruit of creativity. It's what people create that forms basically rights. And, it's often not just the idea that someone has, the creative idea that someone has, but rather the implementation of that idea. When somebody takes an idea and then takes steps towards implementing that idea, turn it into something more developed, that is when intellectual property typically gets created. We talk about it as a property right. That is because intellectual property provides exclusive monopoly-like rights. So just like if you own real estate, you can keep people out. Owning intellectual property means you can stop people from doing what you're doing, and that gives you some financial advantages, your clients some financial advantages and other advantages. As I'll show you on the next slide, it's basically created as a function of the government trying to provide an incentive. The government is trying to incentivize people to help develop technology and move things forward, to help develop culture and move things forward, and to protect reputations and protect consumers, which we'll talk about in a little bit. A key thing that many people not in my field forget is or don't realize is that intellectual property it's a territorial right. Not territorial like a badger, but territorial in the sense that it is limited to a particular geography, to a particular country or jurisdiction. And so when they are interested in doing things in other jurisdictions, or they are doing things in other jurisdictions, or they're worried about others doing things in other jurisdictions, rights can come into play in multiples, right? You might have to pursue intellectual property rights in other places. And that is a place that people often forget. They, particularly in the United States, there tends to be a very US focus, and we forget about what's going on in other countries and whether we have a need, or we somehow think that rights that we get here apply everywhere. There are a whole bunch of international treaties involved with intellectual property. Most of those treaties are for convenience, to take what you might have done here and then seek those rights in other places. There are only a few or very little that actually give legal rights or enable rights in other countries based on the rights here. So it goes again to that point about the territoriality of the law and of the rights. Looking on the right side of the screen, this is often a pitfall because many intellectual property rights are automatic. They come from the fact that you create the item. We're recording this Zoom, so there's intellectual property in this Zoom recording when it's completed, or in my slides when I put them together. Just doing that creates the intellectual property right. The rights are automatic, but when they're automatic in that context, and they're not always automatic, but when they're automatic in that context, they're usually much more limited than the rights that you would get if you actually sought to register them with the government, and ill-defined. And so there are a lot of benefits to seeking registration, some of which we'll talk about. And again, going back to the territoriality, just because the rights are automatic in one place doesn't mean they're automatic in another place. So you have to actually think about, do I seek to register the rights at home? Do I seek to register the rights abroad? And so I guess that covers that. So in terms of being automatic, it's also about whether the rights here apply elsewhere. So even if I choose to go and register, my copyright in the United States doesn't necessarily mean I have those rights and can enforce them in another country, or my trademark, as an example. Intellectual property can have significant issues when it comes to timing. Some aspects of intellectual property require that you take immediate action, or action within typically a 6-month or a 1-year period. So it's very important to be aware of.
3 closings today.
You got he's on mute here. Let's mute him there. Okay, great. So timing can matter. Some things require you to take immediate action or action within a year. Other things, you don't necessarily have to take action, but it's usually beneficial or intelligent to take early action with regards to intellectual property rights. In the context of financial planning, for people who are in accounting, you may see intellectual property often in the context of mergers and acquisitions, and other types of transactions. Intellectual property is used in transactions all the time, and it's fairly easy to acquire intellectual property rights in a transaction. What most people don't often realize, if they haven't been exposed to it, is the actual creation of the intellectual property rights is not a simple transaction. It is typically a process, one that often takes years. So it is something to be aware of when you identify something that might be protectable as intellectual property, not to sort of think of it as a widget.
So Matt, what is that process? I know Phil had asked that.
Well, that depends on the intellectual property right. So there's a process. So we'll get into a little bit of the different types of intellectual property, but there's a process, for instance, of filing to obtain a patent that involves preparing an application that has to meet certain grounds, fighting with the government over what the scope of that right is, and whether people who came before you somehow prevent you from being able to get it. Ultimately getting it published, allowing others to raise objection to it, and then ultimately getting it granted. And that's sort of the typical process. It could take months. For a patent, it might take years. Similar for trademark, right? Copyright tends to be faster, but there can even be a process there. So the process does vary depending on the intellectual property, right? We can talk more about it if desired, but I'm going to go on. As accountants, financial planners, investors, you also might want to recognize that intellectual property has issues tied to it with ownership, right? There's ownership and chain of title, just like there would be for real property, for real estate, and who owns that property, and how it, and to whom it gets transferred. That can have tax implications, and other financial implications. So there's a lot of thought that goes into who should be the owner in order to get tax benefits. And I'm not an estate planning attorney or tax attorney in any way. So, I'll say those things and move on. So if you want to sort of a shorthand to think about intellectual property, think of property, right? You've got a fence. You've got your property that you have fenced in. That's what defines what's yours and allows you to keep others out. Somebody shows up on your property, you get out your gun. Hopefully not. But right, the idea is that you can keep people out. It is a right to exclude. The other thing to remember about intellectual property is it's a deal. Now, whether or not you want to shake hands with this particular person, I leave to you, but it is a deal made with the government. So you are, at least often saying to the government, look, I'm going to share with you this thing that I've created. I'm going to make it available to the public. And in exchange, you're going to give me this monopoly. That's the deal that you can choose to make in order to get in the context of a patent right for your invention, or in the context of a copyright, your exclusive rights in the work that you created. The rest of this probably is not so interesting to you, right? IP is founded in the Constitution. That's where it comes from. And then there are statutes that apply to the various different types of intellectual property. I mentioned already, it doesn't really protect your idea. It really protects the implementation of your idea. But depends on what the idea is. Sometimes there are ways to take small steps to implement the idea and still protect it. So you have to see. You should think about who benefits from it, right? The government benefits, society benefits, the owner benefits, consumer benefits, right? And there are all these different parties that are involved in why there are intellectual property rights. Digging down into the different kinds of intellectual property rights, the ones you hear most about are these. Patents and trade secrets. These are usually things that are useful. They're useful inventions, they're processes, they're machines. With patents, they can also be ornamental designs, and that's not always under patent law, but in the United States it is. So that can be sort of the design of my product and what it looks like. There are patents on artificially reproducing plants, or I should say asexually reproducing plants. There are, so those patents, I put patents with trade secrets. Trade secrets are not patents. They are really the converse of patents. So the patent is if you make the deal with the government. You say, I'm going to share with you my invention, and then in exchange for that, I'm going to get this patent monopoly right. But you could choose not to make the deal. And if you choose not to make the deal, you can keep your invention as a secret. And the Coca-Cola has done this, right, with its secret formula for hundreds of years. The idea there is I decide not to share it, and the government doesn't get the benefit, and society doesn't get the benefit of what I've created, but I protect it as a secret, and the government will help me assist me in protecting my secret, my trade secret. Another type of intellectual property is trademarks. Trademarks are really about reputation and the shorthand that people use to recognize the value of a particular product and the quality of a particular product. So the bottom left of my slide, you see my firm's logo. That's a trademark, right? That logo is a trademark for my firm and allows you to refer readily to my firm and think about the quality of the services you received, or if you don't like the quality, that it was not a good choice for you and you shouldn't be utilizing it. Somebody's on a call needs to be muted. I think I got it. Okay. Trademarks don't have to be words and they don't have to be logos. Trademarks could be smells, colors, movies, characters, shapes, combinations of things, the sole of a shoe. So all different kinds of things can serve the function as long as they create the association for the consumer between what it is and what you're buying. Copyrights are the expressive works. Expressive works could be, music or art or a book or a play or something of that nature, but it can also be software code. Interestingly, software is very, very interesting as it applies to intellectual property, because intellectual property laws came about well before software was ever anything that people did. Of course, nowadays, everybody's doing software. And there is no single intellectual property right that covers what someone's doing with software. So often, software, you have to think about a combination of protecting different aspects of it through the different rights that are available. But copyrights can be in all different kinds of creative, expressive works, and that's the basics of that one. One to be aware, thing to be aware is, of course, these are not the only forms of intellectual property rights, and there are related concepts. So, what about a person's name or their image? Right, there are separate rights available. Usually these are state rights that are available in a person's name, image, and likeness, and the commercial use of that name, image, and likeness. That is separate and apart from any trademark, for instance, that they might they might get. They can sometimes have a trademark and still have a right of publicity and use both. Jimi Hendrix failed to do that, or he did it, and then when he died, all he had left were the trademarks because he was a resident of New York. But we'll talk a little bit about that at the time in a little bit. Probably for you as accountants and financial planners, you deal with incorporations, or you've dealt with creating entities, and probably when you've done that, you have noticed that you'll go into a particular state. You'll look at that state Department of State database to see if the company name is available, or you'll use a service for that purpose, and they'll tell you it's available, and then you'll go and incorporate that entity with that name. This is a pitfall because it depends on what your client is planning to do. But if your client is establishing a business name and is going to be utilizing that business name providing services, let's use Rob on the call here. We've got Sandler Training. Don't know if Sandler is a person or not. We'll assume it is, but let's not worry about that aspect. But you've got Sandler Training, and if I assume Sandler Training is an incorporated entity, and when they went and chose that name and chose to incorporate that entity, they might have known, gee, we're going to not only create Sandler Training Inc. or Sandler Training LLC, but we're going to be out there and create a logo and have a name and put out there Sandler Training so people know to come to us for our business development training services. There's your plug, Rob. I gave you a little extra plug time.
Thanks, Matt.
You're welcome. So because if that was the plan at the time that you were incorporating that entity, that is a plan to potentially use Sandler Training as a trademark. And because there's a plan to use it as a trademark, not just a business name that's sort of secret, nobody's ever going to necessarily see or hear, the clearance that's done for the business name is not sufficient, right? If I just go and say, gee, well, I can get Sandler Training incorporated in New York, it's available, I can create that entity, that's not going to help me if it turns out that somebody else already owns Sandler Training nationally as a service mark for educational services. And so when you're thinking about incorporating businesses for your clients, you should be thinking, gee, are they going to use this name beyond the name of their business? Is it going to be out there publicly in relation to goods or services that they're going to offer? And if so, I probably want to do a trademark clearance. Domain names and social media usernames also tie in with intellectual property rights. They are not themselves intellectual property rights, but they serve similar purposes, right? A domain name is really a shorthand to a place on the internet. And if that place on the internet is a branded place and the domain name I'm using is a brand, right, that is essentially tied to a trademark right. So sometimes with domain names and with social media names, there's a need to be aware about trademark rights and not run afoul of other people's rights, and also secure for yourself those rights that you're going to need for your business or for your client. I put here a bunch of the various rights that we've talked about to tell you about what the exclusive rights you get with one of the different with the different type of intellectual property rights are. So with patents, what you can prevent people from doing with your patent is from making your invention or practicing your invention. You can prevent them from importing it if it's a product. You can prevent them from selling it or offering to sell it. With a trade secret, what you can do is prevent them from disclosing the secret. Right, you're using the secret. With a trademark, it's mostly about use. You can prevent people from damaging your reputation, from confusing consumers, or from diluting your rights so that your name becomes less valuable as a shorthand for you and starts to point to others. With a copyright, you can prevent all sorts of copying, distribution, performance or display of what the work is, changing it, and in some instances, you can also control the attribution, make sure that you get credit for your work. Right of publicity, you can prevent somebody from copying, from commercially using your name, image, or likeness. So those are the gist of what you get when you get these different types of rights. But keep in mind, the government doesn't just sort of outright grant these rights. They're not permanent. They're usually for a limited time. That's part of the deal. And it balances them against other interests. In the United States, we have to care about things like free speech. And so in some instances, and let's use copyright and trademark as examples, giving rights in words removes them from the availability for the public to use them sometimes. And the government wants to balance that exclusivity they give you with the need that people will have to use those words and to repeat them. And so there are concepts of free speech that will balance against the exclusive rights and sometimes allow somebody to do something even though your client has exclusive rights from intellectual property law. Similarly with societal needs, right? We're in the midst of a pandemic. If somebody gets a patent on a vaccine, there can be ways the government can allow, or multiple governments can allow people to get access to that vaccine, even though somebody has exclusive rights to prevent somebody from making the vaccine and reproducing it because of a need, right? Or Powers Act, we can get somebody to go and start producing it in quantities, and we can license it out to others because we really need a high quantity, as an example. And antitrust concerns, right? Obviously, if we're talking about monopoly rights, we have to be worried about antitrusts. So we have to think about those. And those balance against the intellectual property rights that governments typically grant. I mentioned this earlier, but it bodes repeating, and particularly for people who are out there doing financial advising, there are dangers in knowing just enough, right? If you know a little bit of intellectual property, if you know the US aspect of intellectual property, or the concepts that I've just gone over from a US perspective, there are dangers of imposing that US perspective on what your client might want to be doing abroad or what might be happening abroad. The laws are different, the ways they're applied are different, and the needs are different. So, I often have even large multinational clients that are very sophisticated and know a lot about intellectual property law and its application, get themselves in trouble because they look at things from a US perspective. Let's take a quick example. In the United States, trademark rights arise in the context of use. That is, in order to own a trademark registration and claim exclusive rights in a name or a logo, as an example, I ultimately have to be using that commercially in relation to my products or my services. So, so I can't usually get that registration in the United States without having that use. But that doesn't apply in, let's say, China. In China, all I have to do is go apply. I don't have to use it. I don't have to use it for years and years later. So if I'm worried that the Chinese are possibly going to see what I did in the United States and copy my brand, and this has happened, hundreds of thousands of times, right, then I might actually try to obtain rights in China, irrespective of the fact that I'm not even selling my product there. Why would I do that? Well, I don't want the Chinese to make a counterfeit, and I don't want them to export that counterfeit. And if I go and get a trademark, for instance, in China, I could potentially block the export of the counterfeit or even seize the counterfeit items in China and control that from the get-go, well before I'm ever doing business there and well before my product is spread out. So there's a timing issue as to, gee, when should I do that? But for a country like China, at least traditionally people are concerned, often a company that's doing business just in the US might also want to protect its rights in China. And someone with a US perspective thinking, gee, well, I'm not using it in China, would think, I don't need to go register. I'm not planning to go to market there. And because of that, they would not think to protect themselves and usually end up chasing the rights later on rather than proactively having them and protecting themselves. So I put here a bunch of questions that I think that you might consider or might want to consider and that could impact when you might need intellectual property assistance. So the first one is, right, is what my client planning to do is that potentially going to infringe someone else's rights? I have to think of that first before my client does anything. Whether or not I'm seeking to register or apply to register my rights, to get my rights in a particular country, I want to know what happens if my client does this. Does this raise any particular risks for my client, such that they're going to have to spend a lot of money defending themselves, or change their name, or rebrand, or stop doing what they're doing. And so you need to know the lay of the land. We talked about the corporate name. How does the client plan to use the corporate name? Because if they're planning to use the corporate name really as a trademark, gee, that could really implicate infringement possibility, as well as the possibility of generating rights for them. Do they already have rights as a result of what they're doing? This will happen in the context, and anybody who's doing estates and trusts, in the context of, clients don't necessarily always go and seek to register their rights. And so sometimes there are rights out there, but they're not defined. They're not numbered and identified in a way that you can just readily put down on your balance sheet. So how do I identify what rights someone might have if not everything is recorded and has a number that I can refer to, and a document I can refer to? Ownership, we talked a little bit about, but keeping track of the ownership and the chain of title, succession. Then we have, is the client already taking steps? Are they already maintaining those rights? Are they already enforcing those rights? In what way? Have they sought to register? And if so, what did they register? Where did they register it? When did they register it? And how do they go about it? Right? All different aspects of, is what they're doing sufficient, and will it be helpful to you to be able to list as an asset, and what does it actually mean that they have it? If you have an established client, just the fact that you have, that they have some of these things, maybe they have all these things taken care of, they also make changes in their business. I have a client that was selling, had retail shops selling juice, cold pressed juices. And they changed their business in the wake of the pandemic because nobody was going out buying juices in a retail shop. And they said, we're going to do an online grocery delivery. When clients make a change in what their products and services are, or they add products and services, right, that implicates intellectual property rights and could mean that they should take other steps to protect themselves beyond what they were doing previously. Similarly, when they decide to expand into other markets, whether they have immediate plans or those plans are long-term, planning for that early is important from an intellectual property perspective. Then you also need to think about how your client's going to earn their revenues. There are all different ways that you can earn revenues from IP, and what are the values that are coming in. I'm sure that's going to impact you in terms of your financial planning and accounting advice. And then what is the present value of the IP, but how might it change, right? It can change over time. People, you hear about the recording artist whose music was unknown, or the visual artist whose artwork was unknown, and then they died and then it became, very valuable. So it can be, it can change over time, and there are valuation techniques available you may be familiar with in terms of determining the value of the IP if you're going to transfer it. And if you're going to license it, how do you decide what it's worth? And how do you decide what it's going to be worth? Whether it's going to go up or down, and by how much? And of course, there are tax implications of owning the intellectual property and of the revenues generated. There are costs, there are ongoing costs. So some of these intellectual property rights require a continued stream of efforts and payment over time. And there are other liabilities that can arise. Sometimes even being the owner of the intellectual property right means that you're the target. So if you're going to allow your individual person client, your high net worth individual, and that person's going to own their intellectual property, then if there's a problem with that product or an issue there's a lawsuit, right? They're on the receiving end of that. They don't get the protection of the corporate structure. So often you want to put these in a corporate entity. Sometimes you'll put them in a holding company or in a trust, right? As a way to protect the principles. But when you do that, then you have to put licensing in place to allow the people who want to use it to be able to use it if it's not going to be owned by the company that's operating, utilizing the intellectual property. So those are some questions to consider. I've mentioned a little bit of infringement risks. How do I evaluate infringement risks? Typically from a invention perspective, with patents, you can do a search and an opinion to determine if something is patentable, and you can do a search and opinion to determine if what the person is doing will infringe somebody else's patents. Are they free to operate to do what they're planning to do? From a trademark perspective, you can clear the trademark. You can do a search to try to identify what other trademarks are out there that cover similar marks in similar places for similar goods and services, and make a determination as to whether the trademark is available for use and whether the trademark can be registered. We talked about the corporate name. I put domain name registration here because frequently you'll see, if you're talking to your clients about the possibility of a corporate name or of a trademark, that they'll want to go out and register the domain name and the social media names, and they'll kind of do that early on. Know that those don't generate rights. They do get exclusivity in the name because they've registered it for that time period that they haven't registered, but it's not a government right that they can use and take to court. Subject to terms and conditions, etc. But the trademark potentially could support the registration of the domain name. So typically you want to do those things concurrently. While the client is thinking about adopting a name, you're thinking about, gee, is the name available? And you're looking at it from a trademark perspective, and you're also looking at domain names and social media names and going to register those right at the same time you're applying to register the trademark. Not before, because you can give a hint as to what you're doing, and then somebody can beat you to the punch. And also you don't want to find out that you registered a domain name that violates someone else's trademark. Another thing that I see frequently, particularly with small clients and startups, are the sources of works. Where do they get the images? Where do they get the text? In the modern world of the internet, information is readily available. People can readily grab things off the internet and use them. Where did they get their inspiration? Did they take a picture that they found on a website and use that because it was useful to them? I represented a travel agency that had done that with a photo of a particular destination that was a photographer's photo, and the photographer came after them just because they had grabbed that image and used it in their advertising on their website. And the photographer came after them for thousands of dollars to get paid on the use of his image. So there's an element of being aware of where these things come from. And there's an element of education and training, right? Going and helping the clients understand some basics here so that they don't go doing that in terms of, copying or tweaking something that they readily find, taking a name because somebody else had a great name and they liked it, right? Helping them to understand what's safe and what are good practices, and when to get help. So I talked a little bit about some rights being automatic. So copyrights are an example of automatic rights, right? When a work is tangibly fixed, when we record it, when we write it down, right? That's when the rights arise, and there already is a copyrighted place. In the United States, you can supplement that right, and it's usually a good idea to do it, especially if there's someone who's going to be copying, or if you want to be able to stop people from doing it on the internet, where you can go and register that copyright. In some countries like the United Kingdom, they don't even have a registration system. You can't go register a copyright. There is no copyright registration system. It is just, you have a copyright. There are systems that are private that are in place to support people's rights in the United Kingdom as an example, but government registration is not there. Typically, why do you want to register it? Well, you want to go through that process because if you have the registration, you can hold it up. You've got a certificate. You've got a number. You can refer to it in your balance sheet. You can You can use it to take down something that someone put up on YouTube or on some other site very quickly. You can take them to court, and typically you have to have that registration to really go to court and fight with somebody for violating your copyrights. In court, you also can be entitled to damages that are defined by a statute that are a higher range and more valuable and are on a per copy basis. So there's a good reason to go and register copyrights. And I think you'll find if you talk to high net worth clients that have created anything expressive, like written a book or something like that, that it's not common for people to go and register their copyrights. They just don't think to do it, or they think about the quote unquote poor man's copyright, where what they do is they write the chapter or the book, and then they send the manuscript to themselves in the mail and never open it and think they have protection as a result of that. Right? That's not the way in which copyrights are generated. The copyrights are generated by the fact that they wrote the work, but they would want to go register those rights. And copyright's very inexpensive to pursue, so there's no reason not to. I'll give you an example later on that'll tell you a little bit more about that situation. Trademarks, we talked about what they were. Like similarly, rights are automatic. If I use my trademark commercially, it generates trademark rights. Those rights can be more limited. They're called common law trademark rights. They might be limited geographically or limited to the specific product or service that I'm providing. And registration will usually give you a much broader scope, cover you for the whole country, cover even related goods and services that are not necessarily the specific thing you're doing, and then gives you access to other things like the Amazon brand registry if it's a product, or the ability to register on these new domain names that are out there now, where the end of the domain name is not .com or .org, but rather a keyword, for instance, like .food. Rights of publicity, those are automatic. You don't register them anywhere, and there's nothing to be done there. Trade secrets are also, as long as you've taken the steps to protect them, are automatic. They're not registered anywhere. But patents are not automatic and are not registered. Patents are things you must apply to get, and you must apply within the first year of public disclosure in the United States. Again, taking a U.S. perspective is a big problem here, because even though you have that grace period of a year from when you publicly disclose your invention in the United States to get the patent, in most other countries around the world, you do not have any grace period. So what you need to do is go to the patent office and get your patent first. File your patent application before you ever disclose it. And so this is the reason why you'll see a lot of non-disclosure agreements before people will share this type of thing, and that's one thing that's important to do. And you'll also have attorneys like me encouraging clients to pursue those patents early, and there are ways to do that. Within budgetary constraints, right? If they're expecting to have a patent that's going to be useful, an invention that's going to be useful around the world or in many jurisdictions, right? There are ways in which you can seek early protection in the United States, use a treaty to essentially ultimately get the rights in the other countries and not be precluded by the fact that you have disclosed your work, and push the costs down the lane to pay. For you, I think you're going to see that your clients are going to have a lot of unregistered rights. It's common, and I think a common pitfall when you're dealing with advising clients financially and in accounting is that you won't necessarily know that they have rights or what those rights are. They're hard to define, they're hard to identify, they're hard to even describe, and hard to value because you don't have a sense of the full scope when you're just looking at a right that was created automatically. So it can be much better to register these rights, apart from the reasons I mentioned, because you've got something you can readily identify. You can put it in your annual report, in your balance sheet. You can refer to it by number. People can look at it and see what it is. Investors can identify it. Your accountants. So I put amortized. Of course, I don't even hardly know what amortized means. I mean, other than when I do my income taxes. But right, these are things that people have over the course of years. They are assets that last over time. So they're assets that you may be able to do things with from a tax perspective when you're thinking about those rights, if you understand their terms, which I'll give you a little bit about. They can be securitized, right? I can take my trademark registration, my copyright registration, my patent, and I can go to the bank and I can use them as collateral for loan. This is frequently done. What many people don't realize is that those, when you are securitizing an intellectual property right, you can also record those essentially putting a lien or security interest against those properties in the respective offices, in the patent office, in the copyright office, and that can be utilized before transactions are made, let's say to assign it in full or something like that, for to follow the chain of title and make sure a right is clear. And so in the context of a merger and acquisition, right, we can do due diligence and see, gee, you know, there's a security interest. Was that ever released? What's going on here before you know, you take ownership of this property? So something to consider. Of course, if you have a registered right, it's easier to license it. You refer to it. It's easier to assign it. Assign it is transferring it, selling it. It can be more easily enforced. I use the example of taking down on the internet, and it can be evaluated. What I mean there is that is actually obtaining the value, right? You can use accounting techniques to determine the value of the right more easily because you know what the right is.
Hey, Matt, we're a little limited on time. I do want to get to some of the questions. I know Larry Bloom, you had a question regarding a device, and
just because we're limited on time, could I rush through the last couple slides just so people know what's there,
sure.
and then stop with the questions? Do we stop? What time do we stop?
Well, we usually stop around 9, but we'll go a few minutes late.
All right, I'll rush through these the last slides.
Okay.
Just about ownership, we talked about aspects, but sort of several things come into mind. I think the thing to know is that there can be employer and university employer policies that impact who owns intellectual property. The rest of this, I think you can figure out, so I'll leave it off. Here are the terms. I can share the slides after the presentation with Neil, and he can distribute them. But this tells you when you know, how long things last, and in the United States, as an example, they're not the same everywhere else. You know, but that'll help you determine that, and when payments are due on some things, or when they have to be maintained. I think we talked a little bit about this. I mean, some of these things you actually have to, the statute of limitations, and some of these things you actually have to utilize in order to keep the rights. So that's just something to keep in mind. And then I've got these two examples, which I think maybe I won't do, but in the interest of time, because you have questions. But these are examples of real instances where IP rights came about, and IP rights had issue with what the client was trying to do, and how did you go about it, and what kind of solutions were available in these two examples. In this one, it was a publisher wanted to republish a book by a university professor who had died a long time ago, and how did we figure that out? And then this one is an example of a major multinational company that developed a logo using a graphic designer, only to find out that the logo was taken from a stock image photo site, a royalty-free stock image photo site, and how that impacted them. So these were concluding remarks, so I will jump to your questions. Sorry, go ahead, Neil.
So Larry, you want to ask your question?
Sure, thank you. So let's say if you're advising a client, I'm your client. I'm a surgeon. I developed a surgical device, but in coming up with that device, obviously there was a schematic drawing. And then what I did was I named my device. Let's call it the Bloom Remover or whatever, for whatever it's called. So I'm your client. I guess, are you recommending me that I, again, patent the device because it's a physical thing that's used in a process? Trademark or service mark, I guess, the schematic. And then also the name, I guess, there's a trade right to it, I guess. So you could have multiple different types of property protections, is what you're saying, on one particular device.
Yeah. So probably in the instance you've described, the most important aspect would be the patent, right? So we would be trying to protect, a utility patent, meaning a patent protecting what your device does. And that would be the priority. But for instance, apart from the fact that your device does a particular thing and serves a useful purpose and can be patented, it may also have a particular appearance, and that particular appearance, even if it does something that other people's inventions can do, I want to protect the way it looks and that can be a design patent, or it can also be something called trade dress, which is kind of a trademark. Yes, the name could be a trademark, or the logo could be a trademark. Sometimes the shape or other aspects could be a trademark, even the smell. I would probably not be talking about the schematic. The schematic would probably be included in the patent application, but not sought to be protected, unless I was really worried that people were going to make illegal copies. We're going to make copies of my schematic or distribute my schematic. I mean, I could register it as a copyright, but probably wouldn't, at least not immediately. And you could do it if the problem arose, you could decide to protect that. But yes, so any creation could potentially have multiple forms of intellectual property, and usually there's a prioritization and a timing aspect because of financial reasons as to what clients will want to do. And my role will be in part to steer them towards the thing that they should do first, and what things they can put off. But yeah, I would say that's appropriate.
Okay. Thank you. And Rob Fishman had a question. And by the way, Rob's also a professional musician, so you guys have a lot in common. I haven't heard Rob play, but I have heard Matt play, and I can tell you he's damn good. So with that, Rob, you were going to ask about.
I think, first of all, excellent stuff, and I thought the points are well taken, Matt. The question for you is really about how the group can help you. Aside from the introductions that we have to clients, we always look at our strategic alliances, and I'd ask you, who would you say your ideal referral sources would be? I would imagine a CPA would be ideal, and there are several here, but I guess the rest of it is, what other types of professions or businesses do you see, if you could put it into, anywhere from 3 to 7 different types of professions in your experience that you find your referrals come from?
Yeah, thanks. I really appreciate the opportunity and the question. Certainly CPAs, and I work with a number of them. So that's a no-brainer. Often it'll be directly from small businesses that are startups, officers or principals of those businesses. It could be directors of marketing. Directors of marketing or other officers, but usually directors of marketing are, it depends on where the client is, right, in their process, right? But a director of marketing would be thinking about how they're going to get the brand out there. So there'd be trademark issues and issues that go often internationally.
Okay.
And then from an industry perspective, IP applies, and you saw from my beginning about slide, right? IP applies to all different industries. It applies in different ways, right? We talked about a surgeon, or we could talk about a musician. So it's just, there's no specific single industry. I can tell you that in my experience, I do a lot of work in food and beverage. I do a lot of work in finance and investment, and payments and things of that nature, insurance. I do a lot of fashion and clothing, jewelry, and software. I'd say those are the most frequent, but I've done paint. So it could be whatever.
Did you mention that you were on staff at Columbia?
I didn't mention that, and I'm not on staff there, but I did teach for a few years as a professor for a program at Columbia.
One of my very close friends is a professor, just got a full-time job at Iona College. He comes from the food and beverage industry, He was the CMO most recently of Tate's Cookies, which sold.
Sure.
But also he worked for Snapple. He's a professor at Iona full time, but he'd worked at Columbia also. But in terms of your connection to the food and beverage industry, he'd be a great introduction. I mean, you two could definitely meet each other.
Absolutely. Yeah, and much appreciated.
Sure.
You got other questions?
Anyone else have any other questions? I'm going to conclude only because of time and just say, Matt, thank you so much. Terrific job. We will be sharing Matt's contact information with everybody and do a follow-up email. And I hope everyone has enjoyed the presentation. I hope everyone is safe. I hope people are figuring out where their kids are or aren't and making preparations. I know it's crazy times, and we're going to make the best of it and keep moving forward. Our next meeting will be about nonprofits. We have and we'll also be touching base on charitable remainder trusts that I will be doing a presentation on. We'll have a nonprofit CPA specialist who works in New York City. Lawrence, I don't know his last name in front of me, who's also a professor in this particular area. And hope that you can come, and thank you for your support, and look forward to seeing you in 2 weeks. Have a great day,
Thank you very much for
everybody.
having me.
Thank you.
Are you sending out calendar invites for these meetings?
Good job, Matt.
Absolutely. You will get invites.
Okay, appreciate it.
Hey, thanks. Take care.
Labor Day
Thank you,
holiday,
everyone.
everyone. Take care.
Thank you.
Be well. Stay
Bye-bye
safe.
now.